So in my paper, I wanted to address the themes of the conference in terms of the relationship between citizenship and rights, particularly focusing on immigration and the sans-papiers in France. But also today with the referendum results, I kind of woke up and I felt pretty disillusioned, so I kind of changed the first part of my paper. And I'm gonna start with Hannah Arendt's critique of nationalism and use that as a way into the rest of it. So Hannah Arendt criticises the abstract nakedness of universal human rights, claiming that they're effectively meaningless and dangerous. She invokes the right to have rights as the only universal right, identifying the fundamental aporia of human rights, where despite their claim to universality, rights are only ever granted to those who belong to particular political communities. So in a contemporary context, with accelerating levels of migration, the referendum, the refugee crisis, this could hardly be more relevant. But rather than trying to overcome these contradictions between the universal rights and their dependence upon particular communities, I want to investigate some of these paradoxes and what they illuminate about the themes of this conference and new ways to think about these categories. In so doing, I argue that by situating acts of citizenship within a broader theorization of law, the rights-claiming migrant comes to represent the idealized citizen. In so doing, they reveal the constitutive tension between rights and citizenship, where each is the condition of possibility of the other. And then here, the contradiction between the universal and the particular, which was displayed in the right to have rights, shouldn't be seen as an opposition, but as a structural necessity right at the heart of the political. So, in The Origins of Totalitarianism, Hannah Arendt touches on this perplexity of right claims, starting with the Enlightenment Declaration of the Rights of Man and Citizen and the French Revolution. And for her, this is a quote, the paradox is that the same essential rights were at once declared as the inalienable heritage of all human beings and as the specific heritage of specific nation-states. The same nation was at once declared to be subject to laws which would flow from the rights of man, and sovereign, that is bound by no universal law and acknowledging nothing superior to itself. And the result of which for her was this perverse elision of nation and state, but obviously is very alive and well today. So we see that far from being universal, rights are granted to those who belong to particular political communities, and then statelessness is something that is tantamount to rightlessness, and the culmination of which for her was the Holocaust. So to make this point today, of all days, Arendt saw the Holocaust not as the exclusive problem of particular nation-states, but as an abuse of the contradictions that pervade the nation-state principle, culminating in Hitler's claim that right is what is good for the German people. And despite extensive human rights laws, these things are still intact today, as we can see with all these migrants, refugees stuck in liminal zones of rightlessness. Which kind of leads to the question of how you might overcome it. And the simple answer is you can't. But I think that's also what's interesting about this subject is maybe looking at these concepts in new ways. So in a text called Being Political, Engen Eisen offers a genealogy of citizenship that comes to recognise its agonistic dimension, the fact that it sort of necessarily excludes others. His understanding of citizenship does not necessarily imply formal membership of a nation-state, although obviously that would be one form, but rather means to be included in any form of political community, but then by its very nature excludes others. Citizenship, on this reading, exceeds the nation-state model, or any state-centric model of possession, becomes a process through which subjects constitute their identities as citizens. And in developing this counter-narrative, a strength of what he does is he makes a space for resistance, where we might think of resistance is where those who are excluded contest the terms of their exclusion, politicising their identity in processes of what he calls becoming political. And so he draws a contrast between being political and becoming political. So being political is a much more normative position, which is when a social group succeeds in inculcating their own virtues as dominant. In contrast, becoming political is a much more radical position, and it's that moment when the naturalness of dominant virtues is called into question and the arbitrariness revealed. So throughout history, these acts have redefined the ways of being political by developing new practices that enabled them to constitute themselves as political agents under new terms. And then we have all sorts of historical examples, civil rights movement, the suffragettes, and the sans-papiers today, which is what I want to talk about. But what's common to them all is their processes of becoming political, through which these excluded others reveal themselves as political subjects and lay claim to political membership and the rights from which they were or continue to be excluded. And in so doing, what they do is they redefine and reiterate the meanings of the political community. And his genealogical approach leads to a shift in how we would understand citizenship. So he differentiates between what he sees as formal citizenship, which is a legal status, and substantive citizenship, which would be an activity. And he would say that that is a condition of the possibility of it as a legal status. And so then starting from this substantive understanding, Eisen develops a theory of active citizenship as an emancipatory activity constituted through, and this is a quote, those acts that transform forms and modes of being political by bringing into being new actors as activist citizens through creating new sites and scales of struggle. And I think what's good about his theory is he definitely is right to foreground this active dimension of citizenship. But what I think remains under-theorised is the way in which it interacts with citizenship as a legal status and how it might contest its exclusion. So, in principle, he's come up with this theory to try and attenuate the contradictions of the right to have rights through this form of impossible activism for those who are excluded, but constitute themselves as citizens in substance, but maybe not status. However, I want to insist that all claims to citizenship, while not necessarily founded in law, appeal to citizenship as a status. To speak of citizenship is always already to speak of rights, and these are dependent upon legal personhood within specific juridico-political communities. And I want to demonstrate how acts of citizenship necessarily engage with citizenship as a legal status by turning to the sans-papiers. So on the 18th of March 1996, 324 undocumented migrants, including 80 women and 100 children, occupied a church in Paris. And it marked the beginning of this sans-papiers movement that was a response to increasingly restrictive immigration policies and laws that rendered many long-term residents of France illegal. So following this initial occupation, it spread countrywide. I think 25 different collectives were set up. But also what they did at the same time was they universalised their demands, calling for the legalisation of all so-called illegal immigrants and even further free movement and opening of frontiers. So what was important about this was it's not just a campaign to stop the deportation of particular individuals, but the regularisation of all immigrants who don't have the correct immigration documents. And in making these claims, they challenge not just the French state, but also existing human rights frameworks as well. For example, Article 13 of the Universal Declaration of Human Rights states that everyone has a right to the freedom of movement, to leave the country, including their own. But then the declaration is completely silent on the right to enter a new country and become a citizen there, unless you can prove you're a refugee, which is increasingly difficult. So, in no existing human rights law is it declared that states have an obligation to regularise undocumented immigrants. So, in making their claims, the sans-papiers challenged not only the existing legal framework of human rights, but also the moral universalism that underpinned it. And so despite calling into question this, though, they didn't totally reject the laws of citizenship and its institutions, but engaged with French history to expand and enrich its form of citizenship. And I want to briefly look now just at the opening of their manifesto, because I think it's a really good example of what it means to make rights claims if you're excluded. So it starts, "We, the sans-papiers of France, in signing this appeal, have decided to come out of the shadows. From now on, in spite of the dangers, it's not only our faces, but also our names which will be known. We declare, like all others, without papers, we are people like everyone else." And a few interesting things are happening. So this reference to coming out of the shadows is tied to the creation of a name, which I think is really important in two ways. So in the first sense, it legitimises their project by rendering them as political agents acting on behalf of a group. But also the term sans-papiers is particularly useful because it reveals them in position as not illegal immigrants or criminals, but those whose only lack is a document. And then in this next line as well, where it states, "We declare like all others without papers, we are people," it echoes the Declaration of the Rights of Man, which asserts that all men are born free and equal of rights. And in so doing, it works performatively, so it reinforces the content of what their statement by also showing them as speaking beings whose equality is given through their very speech and action. And in so doing, it juxtaposes a universal to a particular. That is something that I want to claim is a particular to all rights claims, where the claim itself reveals that a universal conception of identity is actually predicated on exactly those who are trying to be included in making rights claims. And then they support this juxtaposition kind of politically. They then say that we thought France was the country of the rights of men. And in so doing, they get to the heart of the universality that lies at the heart of French identity. And in so doing, they deepen and enrich the meaning of citizenship precisely because they lack the authorization to appear. They propose new rights and push already existing rights beyond their institutional formulations. So finally, before finishing, I just want to reflect on what that action without prior authorization means for a brief reflection of the paradoxes of law, justice, that I claim are reflected in the relationship between citizenship and rights. So undoubtedly, the sans-papiers were hugely successful in rewriting the discourse on illegal immigrants, again, repositioning them from zones of illegality and criminality to potential citizens. Also, they gained real concessions. So in 1997, the socialist government came in and they announced that they were going to fast-track the regularization of all sans-papiers. However, at this point, 150,000 undocumented migrants applied. Of that, roughly half got papers, and of the ones who did get papers, it was only for 1 year, so it didn't really overcome the problem. And then of the other half, they were rendered deportable, so they either had to go back into hiding or be deported. So in many ways, this was just viewed as a trick by the French state to deport. So while I completely agree with Eisen, as I said before, that I think citizenship is undoubtedly, as a practice, is incredibly important, and rights movements do have the potential to renegotiate the meanings of citizenship, as is borne out historically with things like the civil rights movement. I think that in privileging the substantive dimension of citizenship over the formal, Eisen obscures the radical foundations of citizenship. And Jacques Derrida touches on this in a public address he gave on the sans-papiers, where he asked, "What is being said, and what does one mean to say when one says sans-papiers?" So he basically asked, what exactly is it that they're lacking, the sans-papiers? And he concludes that, in principle at least, they don't lack anything. Instead, they're victims. They're the victims of rich neoliberal nations and their, economic policies and legal projects to protect their economic privilege. So while the sans-papiers may lack a document, the real problem for them is what Derrida termed the French government's dereliction of justice. He claims that they're in dereliction of justice in offering the right to justice and refusing to offer the universal right to hospitality. So in making this claim, Derrida seemingly paradoxically juxtaposes or opposes justice to the rule of law, which kind of on the face of it seems contradictory, but I believe that this relationship between law and justice is particularly revealing when it comes to acts of citizenship. In The Force of Law, Derrida outlines this paradox of law and justice, where justice is irreducible to law because it is concerned with the realization of this ethical relation to the other and their absolute singularity. So while justice is not and cannot be law, it cannot become justice legitimately except by appealing to the force of law. The paradoxical relation is one of mutual possibility and impossibility. For law to be just, it must appeal to a justice that necessarily exceeds all law, yet the realization of justice requires recourse to the force of law. And I think this undecidable relationship between justice and law manifests itself in acts of citizenship. So the third principle of theorizing acts is to recognize that acts of citizenship do not need to be founded in law or enacted in the name of law, which is a quote from Eisen. But then in the case of the sans-papiers, we see that this is contradictory, because despite the fact that, in the eyes of the law at least, sans-papiers are illegal, and the fact that many of their direct actions were acts of illegal civil disobedience, their demands are based in the French constitutional tradition, and their appeal to citizenship as a legal category is, what defines their movement. And Hannah Arendt, again, is particularly useful on this. She writes on civil disobedience, and she says she wants to find a constitutional niche for civil disobedience. In contrast to criminality, for her, civil disobedience is a political act taking place when the ordinary channels for justice to function are no longer operative or just simply not available to some. In the case of the sans-papiers, rather than seeing their very beings and their action as illegal, civil disobedience is the moment in which the excess of justice over law manifests itself in the form of action. These acts aren't in contravention of citizenship, but support and augment its meaning in upholding the principles of freedom and equality. And then the practice of making rights claims reveals this constitutive excess of citizenship, where the universal rights upon which it's premised overflow its borders. And then at this point, we might go a step further and recognise that the French state, in being in dereliction of justice, this calls into question not the legality of the sans-papiers, but of citizenship itself, where it's in violation of the rights of man from which its authority is derived and its laws flow. And at this point, paradoxically, the rights claiming migrant who transgresses the borders of political communities comes to represent citizen par excellence, calling on the state to do justice to its universal foundations. So, should have added those as quotes, but there they are. In drawing attention to these paradoxes, again, I'm not trying to say that they can be overcome or that citizenship is a redundant category either. Rather, I want to suggest that there is this revealing mutual implication and symmetry in the relationship between law and justice, and that of citizenship and rights, I think, is often missed by theorists who tend to relegate law. As has already been discussed, law is not justice. Justice is irreducible to law, yet also needs law to come into being. Similarly, universal rights cannot be reduced to citizenship. Rights must extend beyond the borders of citizenship, but without citizenship, as Arendt shows, they're completely meaningless and just an abstraction. So in turn, the constitutional documents that found the laws of the state derive their authority from the rights of man, at least in the case of France and America. So when we return to the beginning and think about the right to have rights, what we saw as a contradiction between the universal and the particular turns out to not to be contradictory at all, but a mutually enabling and disabling relationship, where the possibility of justice occurs in the transgression of the border between the two. And I wanted to suggest that is a moment of the political. Thank you.